Hello everyone, welcome back to our YouTube channel KKP The Advocate. Welcome back to the series of Negotiable Instruments Act. In our last lecture, we completely covered chapter 2. Today, we are moving on to chapter 3, which deals the legal capacities, liabilities, and discharge of the parties to notes, bills, and checks. This chapter spans from section 26 to section 45A. Let us break it down line by line directly from the bare act into simple and exam focused language. Let us go through section 26, capacity to make, etc., promissory notes, etc. Every person capable of contracting according to the law to which he is subject may bind himself and be bound by the making, drawing, acceptance, endorsement, delivery, and negotiation of a promissory note, bill of exchange, or a check. Minor. A minor may draw, endorse, deliver, and negotiate such instrument so as to bind all parties except himself. Who can sign or issue a negotiable instrument? Anyone who is legally competent to enter into a contract under the Indian Contract Act of sound mind and major age. There is a topic called the minor exception. It is highly important for exams. A minor is a special case. A minor can draw, endorse, or transfer an instrument, and the instrument remains perfectly valid. It will bind everyone else involved, like banks or adult endorsers, except the minor himself. You can never sue a minor for payment on a check or bill. Next, section 27, agency. Every person capable of binding himself or of being bound, as mentioned in section 26, may so bind himself or be bound by a duly authorized agent acting in his name. A general authority to transact business and to receive and discharge debts does not confer upon an agent the power of accepting or endorsing bills of exchange so as to bind his principal. An authority to draw bills of exchange does not of itself import an authority to endorse. You can act through an agent, but the authority must be incredibly specific. A general business agent cannot automatically sign, accept, or endorse bills to bind the principal. Even if an agent has specific permission to draw or write bills, that does not automatically give them the right to endorse or transfer them. Every legal power in negotiable instruments must be explicitly stated. Next, section 28, liability of agent signing. An agent who signs his name to a promissory note, bill of exchange, or check without indicating thereon that he signs as agent or that he does not intend thereby to incur personal responsibility is liable personally on the instrument except to those who induced him to sign upon the belief that the principal only would be held liable. If you are an agent signing a document on behalf of a principal, you must clearly write agent on behalf of the name of principal. If you just sign your own name normally, the law holds you personally liable for that money unless you can prove the other party completely knew and induced you to sign knowing only the principal was responsible. Next, section 29, liability of legal representative signing. A legal representative of a deceased person who signs his name to a promissory note, bill of exchange, or check is liable personally thereon unless he expressly limits his liability to the extent of the assets received by him as such. If an executor or legal heirs sign a promissory note or check while managing a deceased person's estate, they will become personally liable out of their own pocket unless they specifically write on the instrument liable only to the extent of the assets received from the estate of the deceased. Next, section 30, liability of drawer. The drawer of a bill of exchange or check is bound in case of dishonor by the drawee or acceptor thereof to compensate the holder provided due notice of dishonor has been given to or received by the drawer as hereinafter provided. The person who writes a check or bill the drawer carries a secondary conditional liability. If the bank or drawee refuses to pay dishonor, the drawer must compensate the holder. However, this liability only triggers after the holder serves a formal notice of dishonor to the drawer. Next, section 31, liability of drawee of check. The drawee of a check having sufficient funds of the drawer in his hands properly applicable to the payment of such check must pay the check when duly required so to do, and in default of such payment must compensate the drawer for any loss or damage caused by such default. This section targets the bank who is drawee herein. If a customer writes a valid check and has sufficient unencumbered funds in their account, the bank is contractually obligated to pay it on demand. If the bank wrongfully rejects it despite having the funds, it must compensate the drawer for financial loss or damage to their business reputation. Next, section 32, liability of maker of note and acceptor of bill. In the absence of a contract to the contrary, the maker of a promissory note and the acceptor before maturity of a bill of exchange are bound to pay the amount thereof at maturity according to the apparent tenor of the note or acceptance respectively. In default of such payment, such maker or acceptor is bound to compensate any party to the note or bill for any loss or damage sustained by him and caused by such default. The maker of a promissory note and the acceptor of a bill of exchange hold the primary liability. They are the main debtors. They are bound to pay the full amount exactly when the instrument matures based on its clear terms. If they fail, they are directly liable to compensate any affected party for the loss. Next, section 33. Only drawee can be accepted except in need or for honor. No person accept the drawee of a bill of exchange or all or some of several drawees or a person named therein as a drawee in case of need or an acceptor for honor can bind himself by an acceptance. Section 34. Acceptance by several drawees, not partners. Where there are several drawees of a bill of exchange who are not partners, each of them can accept for himself, but none of them can accept it for another without his authority. These two sections says about who can accept, and these are about multiple drawees. Let us explain in simple language. Section 33 says a random third party cannot just step in and sign an acceptance on a bill of exchange. Only the explicitly named drawee, a designated drawee in case of need, or an acceptor of honor can legally bind themselves. Section 34 says if a bill is sent to three different people who are not business partners, each can only sign and accept liability for themselves. One cannot sign on behalf of the others without clear legal authority. Next, section 35, liability of indorser. Every indorser, after dishonor by the drawee, acceptor, or maker, is bound to compensate such holder for any loss or damage caused by such dishonor. Every indorser, after dishonor, is liable as upon an instrument payable on demand. Every person who signs the back of an instrument to pass it along, the indorser acts as a guarantor to all subsequent holders. If the primary maker or bank defaults, the holder can loop back and demand the full amount from any previous endorser, who must pay immediately as if it were a demand instrument. Next, section 36, liability of prior parties to holder in due course. Every prior party to a negotiable instrument is liable thereon to a holder in due course until the instrument is duly satisfied. This provides ultimate protection to a holder in due course, HDC. If you are an HDC, every single person who handled, signed, drew, or endorsed the instrument before you arrived is jointly and severally liable to you until you receive every single rupee due on that instrument. Next, section 37 and 38 says about principal, debtors, and sureties. Section 37, maker, drawer, and acceptor principles. The maker of a promissory note or check, the drawer of a bill of exchange until acceptance, and the acceptor are, in the absence of a contract to the contrary, respectively liable thereon as principal, debtors, and the other parties thereto are liable thereon as sureties for such maker. drawer, or acceptor. Section 38. Prior party, a principle in respect of each subsequent party, as between the parties so liable as sureties. Each prior party is, in the absence of a contract to the contrary, also liable thereon as a principal debtor in respect of each subsequent party. This constructs a chain of liability using suretyship concepts. The core debtor, who is the maker of a note or check or the acceptor of a bill, is the primary debtor. Everyone else who signs it along the chain acts as a secondary guarantor, like surety. The chain effect: if you look at the middle of the chain, an earlier endorser acts as a principal debtor to the person who received it after them, keeping the chain secure for the ultimate holder. Next, section 39, suretyship. When the holder of an accepted bill of exchange enters into any contract with the acceptor, which under section 134 or 135 of the Indian Contract Act 1872 would discharge the other parties, the holder may expressly reserve his right to charge the other parties, and in such case they are not discharged. Under general contract law, if a creditor gives extra time or makes a private deal with the main debtor, the guarantors, who are sureties herein, they are automatically set free. However, section 39 creates an exception for bills of exchange. A holder can make a deal with the acceptor while explicitly reserving rights to sue the prior endorsers. If those rights are explicitly reserved, the prior parties stay on the hook. Section 40. Discharge of endorsers' liability. Where the holder of a negotiable instrument without the consent of the endorser destroys or impairs the endorser's remedy against a prior party, the endorser is discharged from liability to the holder to the same extent as if the instrument had been paid at maturity. Every endorser, every endorser relies on their right to sue the people who signed before them if things go wrong. If a holder intentionally or negligently cancels, strikes out, or releases an earlier party's name from the document, they destroy the safety net of the latter parties. If you destroy that remedy without their consent, those latter endorsers are completely discharged from liability. Next, section 41. Acceptor bound, although endorsement forged. An acceptor of a bill of exchange already endorsed is not relieved from liability by reason that such endorsement is forged. If he knew or had reason to believe the endorsement to be forged when he accepted the bill. Section 42. Acceptance of bill drawn in fictitious name. An acceptor of a bill of exchange drawn in a fictitious name is not, by reason that such name is fictitious, relieved from liability to any holder in due course. Let us explain in simple language section 41. If you accept a bill knowing full well that an earlier signature on it was forged, you cannot later use that forgery as an excuse to avoid paying an innocent holder. Your knowledge binds you. Section 42. If a bill is drawn under an imaginary or fictitious name, for example, Alpha Enterprises, which does not exist, but the signature matches the real handwriting of the drawer, an acceptor cannot escape liability to a holder in due course by claiming the name was fake. Next, section 43 and 44. Section 43. Negotiable instrument made, etc., without consideration. A negotiable instrument made, drawn, accepted, endorsed, or transferred without consideration or for a consideration which fails creates no obligation of payment between the parties to the transaction. Section 44. Partial absence or failure of money consideration. When the consideration for which a person signed a promissory note, bill of exchange, or check consisted of money and was originally absent in part or has subsequently failed in part, the sum which a holder standing in immediate relation with such signer is entitled to receive from him is proportionally reduced. Basically, we can say about these two sections in a simple language. Section 43. No consideration. If I give you a promissory note purely as a friendly gift without any money or value exchanged, you cannot sue me to enforce it because there is no legal consideration. However, if you transfer that note to an innocent third party for value, they can sue me. Next, section 44. Partial failure. If I give you a check for rupees 500 for goods, but you only deliver rupees 400 worth of goods, the consideration failed by rupees 100. If you sue me directly, you can only recover the adjusted amount of 400 rupees, not the full face value of the check. And then the final sections of chapter 3, 45 and 45a. Section 45. Partial failure of consideration not consisting of money, where a part of the consideration for which a person signed, though not consisting of money, is ascertainable in money without collateral inquiry, and there has been a failure of that part, the sum entitled to receive from him is proportionally reduced. 45a. Holders right to duplicate of lost bill. Where a bill of exchange has been lost before it is overdue, the person who was the holder of it may apply to the drawer to give him another bill of the same tenor, giving security to the drawer, if required, to indemnify him against all persons, whatever, in case the bill alleged to have been lost shall be found again. Let us say about section 45. non-money consideration. If the transaction involves goods and services instead of direct cash and a specific calculable portion of those goods fails to arrive, the court will calculate the cash value of that missing portion and reduce your liability on the instrument proportionally. Section 45A, Practical and strategy highlight duplicate of lost bill. If a bill of exchange is lost before its payment date hits, the holder has a statutory right to demand a duplicate copy from the drawer. To protect the drawer from fraud, in case someone finds the old bill and cashes it, the holder must provide an indemnity bond or security to protect the drawer from double liability. That completes our line by line examination of chapter 3. We have cracked open the legal dynamics of all the parties, their liabilities, and how consideration shapes their obligations under sections 26 to 45A. If this clear legal breakdown helps you navigate your judicial service exams or your law school textbooks, remember to hit the subscribe button and give this video a thumbs up and share it with your peers. Drop your questions below, and I will see you in chapter 4 on our YouTube channel KKP The Advocate. Thank you.